So this is the second day of our 35th anniversary conference. We have a very full day, so I'll go straight to introducing the first panel, the chair of the first panel, who is John Barber, Michael Brown lecturer at King's and former director of the Center of Construction Law and Dispute Resolution, who indeed was director and sat on the panel when I was interviewed and joined King's in 2013, so almost 10 years ago. Obviously, I don't know whether John casted a vote in favor or against, but these are secret deliberations. So John was a speaker at the first and second center conferences in 1988 and 1989. Then in 1992, he became a part-time member of staff. Then he was appointed Michael Brown lecturer, and since then really has been at the center in various capacities, importantly as director for 4 years. John, in a sense, embodies the interdisciplinarity of the center because he is a qualified civil engineer as well as a lawyer. And has worked not only, of course, in England and in the UK, but also in Hong Kong and Cameroon, and has experience both in non-contentious construction law projects, contracts, but also in dispute resolution, arbitration, and particularly adjudication. He's a fellow of the ICE and the CIARB, served for 7 years as a member of the Standing Committee on Structural Safety, and for many years he was a member of the ICE dispute resolution panel. So I'll hand over to John for the panel on key issues in English construction law. Thank you, John.
Thank you very much, Renato. Well, before I introduce the speakers, I just want to deal with a couple of things. First of all, I just wanted to respond to Hamish Lal's what I felt was a rather strong implication that there is a conspiracy by pale, stale males to exclude women from the role of adjudicator. And I confess that although my contemporary Charles Windsor has just started a new career down the road, I qualify as pale and stale and male. But I can't speak for TEXA or TECBAR or RICS, but I was a member of the ICE dispute resolution panel for probably 10 years and examiner on adjudication law and practice for admission of adjudicators. And I have also observed what goes on in the RIBA. And I can say that certainly within the ICE, on the DRP, which was the controlling body, certainly towards the end, we had 2 female members, including latterly Lindy Patterson, and there was certainly doing our best to encourage adjudicators generally, people who wanted to be adjudicators generally, to apply, and particularly to encourage females to apply, because it's only if women come forward to be adjudicators or to join the registers or panels that this can be changed. And certainly when I had dealings with the RIBA, the head of the equivalent body of the RIBA, the chief person there, was Sue Lindsay, who is a past student of this centre. She was an architect, then converted to the bar. So I don't think it's unhelpful to suggest that there is any conspiracy against women becoming adjudicators. And I was particularly pleased, actually, last night while we were having drinks, that one of our past female students came up to me and said, what can I do to become an adjudicator? And she had the great fortune also to be a civil engineer, so I was able to advise her directly. And I gave her some guidance, the main bit of which was the best way towards being an adjudicator is to practice as a representative in adjudication in the same way that judges start off as barristers acting as counsel. Because you can see the problems of adjudication, you can observe adjudicators in action. And also, I was able to say that the MSc is a tremendously good foundation for anybody who wants to take on the role of adjudicating, providing a background in construction law and adjudication law and practice. And the Centre has a tremendously strong record in encouraging women to become students and then to make the most of their time on the course. Now, just by way of example, I note that there was a CEO of a top 40 contractor who was a female past student of this centre. I met somebody who was top person in project managers, Turner and Townsend. She was leading their London team. So, the centre and the MSc provides a very strong foundation for women who want to progress at all levels. But I also want to take a little trip down memory lane, and I can recognise a few people who weren't mentioned yesterday. And just also to start with a history that we weren't actually the Centre of Construction Law and Dispute Resolution at the beginning. We were the Centre of Construction Law and Management. And I mean, part of why we ceased to be that was because Martin Barnes didn't come on board. But it's interesting that certainly in the AL module, that's my speciality, we are moving more and more to emphasis on management. And I can well see a time in the future when the Centre will get back to its roots and bring in management as well as law. And it was also the MSc in construction law and arbitration, not and dispute resolution, because there was no adjudication when we started. Just to pay a few, sort of remember a few people who have been terribly influential, I would start with Sue's predecessor as manager. There was Pauline Gale, who some of you may remember as the manager for the first 10 years. If you met her, you'd never forget her. And she was followed by Linda Jones for 12 years, and they both made tremendous contributions in keeping the centre together. But I've got to pay tribute to John and Philip, and I would just pick out a few qualities. One was their ability to inspire. Anybody who ever sat through the opening introductory sessions and when Philip and John were running them, and Philip gave that little spiel with his twinkle in his eye about how this MSc was going to change your life and how you were going to get up early on a Sunday morning and talk to your long-term meaningful domestic associate on some topic of construction law, and you could feel the influence was palpable. And then John would tell people how when they wrote their dissertation, it was their opportunity to make their mark on the field. And people responded. Then there was John's ability to raise funds because the centre was required to be self-funding. And John's ability to persuade leading firms of solicitors to cough up huge, eye-watering sums of money to sponsor our conferences was beyond belief. And he also persuaded Bill Brown, who was the father of Michael Brown, after whom my lectureship is named, to endow the centre with very substantial funds. But we were not we raised lots of money. We were not a money-spending organisation. And John's motto was twice the quality at half the price. And I think we always used to deliver that. I hope we still do, although the college now controls the fees that are charged. But they also had the ability to bring on board people of the highest caliber from the very top of the tree to contribute and to make enormous contributions. Philip in the academia field, John in construction and professions and in the legal field. And you can see the evidence of this if you look at the list of people who spoke at the first conference on construction contract policy, for example. I was recalling, because I spoke there, that John would give you a title, which wasn't the title you volunteered to do, but it wasn't possibly a topic that you were particularly familiar with before you got the commission to go out and prepare a paper and produce a very substantial written paper. And Philip managed to bring on board as external examiners people from the top of the tree. And in those days, the external examiners had a very great influence and contribution to make, much more than they do now. And we can look back on Professor Hugh Beale, Professor Michael Firmston, Professor John Powell. I don't know, I don't think John Powell is a professor, but he's part of Jackson and Powell on professional liability. And Professor John Cartwright, I remember. I mean, there are others, but I picked those out as notable examples. And we had two permanent externals from the beginning. There was Professor Donald Bishop, who John mentioned yesterday, who was a source of great wisdom and strength. He was a marvelous person. And also Judge Anthony Thornton, who was appointed to represent the interests of the Society of Construction Law. There was a time when the college objected to us having these permanent examiners, but I wrote back to them and told the college, the admin staff, that they were eleemosynary examiners, which just means that they weren't paid, but it was sufficient to confuse the administration, and they never objected again. Then we had visiting professors that came on board. Ian Duncan Wallace and Max Abrahamson. Enormous characters that contributed so much to the centre. Ian Duncan Wallace, well known as the author of Hudson, but he also produced two mammoth tomes of his papers entitled Construction Contracts, Policy and Practice, which are still worth reading. And then more recently, we've had Sir Vivian Ramsey come on as a visiting professor, duly qualified as engineer and lawyer, who probably those who have been here more recently will have encountered. Then I remembered Anne Netto. Anne Netto did her PhD here. She came from Singapore, and then she went back to Singapore. And it was with Anne Netto that Philip Britton set up the MSc with NUS in Singapore. And she led it to begin with great success. And the influence of the Singaporean experience has fed back into what we do in London to a very substantial extent. John and Philip managed to bring on board practitioners to deliver lecture, practitioners who were willing to adopt or who had an academic perspective, who didn't just look at what they did in a professional sense. They could make sense of it at a higher level. And it's interesting, the centre was not merely somewhere where academics brought on board practitioners. It was one that was run by people who were jointly academic and practitioners, which is perhaps rather different to the sort of academic-led norm that exists. There were just a couple of people who would have been here had they lived a few years longer. They were taken earlier. One was Francis Patterson, who was a great supporter of the centre in the very early days, and also John Rushton, another great contributor. And finally, I just mentioned the students. I mean, I don't know whether you realise, as students, how much you have contributed to the development of the centre. In particular, through your questions and challenges during lectures and tutorials, and also writing dissertations. I mean, the process of supervising a dissertation, I've always found one of the most satisfying things that we do as academics. And we shouldn't forget the KCCLA, the Alumni Association, which has, others look on in envy at how we have such an active alumni association, which contributes so much. And I'd single out Anne Wright, who has been one of the leading lights of the KCCLA for so many years. Anyway, moving on to what I'm here for, which is to introduce the four speakers. I'm going to follow the route that Philip started yesterday of introducing them all so they can just progress. Yesterday, we ended on what you might call soft law, with David Mosey leading it. Today, this morning, both sessions are what you might call hard law. We're back to the roots of the centre, looking at the hard legal issues, rather than the cuddly bits that David has managed to help us to see are important as well. We have Richard Wilmot-Smith, KC, who will speak on performance bonds and bank guarantees, 35 years of development. Richard's been in Silk since 1994. He sits as an arbitrator and adjudicator worldwide in high-value cases involving construction and engineering generally, European law, environmental law, libel, health and safety, railways, and oil and gas. He also has an academic side. He lectures on international arbitration and construction law extensively, including recently in New Zealand, Hong Kong, Delhi, and London. And even more importantly, he is the author of a very substantial book, first published in 2006 under the title of Construction Contracts, was it Principles and Practice, I think it was. It's now in its 4th edition under the title Wilmot-Smith on Construction Contracts, and he has stepped back from being the author to being the editor with lots of other people doing the hard work. Then we've got Julian Bailey, who will speak on the meaning of fitness for purpose. And he was just pointing out that, was it Humphrey Lloyd that spoke on fitness for purpose back in 1988. Julian is a visiting fellow at the Dixon Poon School of Law because of his contribution on the course here. And he's also an adjunct professor of law at Hamad bin Khalifa University, Doha. His day job is as partner with White & Case, practicing in the firm's international arbitration and construction and engineering groups. He was chairman of the Society of Construction Law 2015 to 2016, and he has in recent years made a tremendous contribution to construction law in the shape of a 3-volume set of books under the title of Construction Law, which you can look at copies back on the back table there later on. Tremendously learned and very comprehensive set of books, which I commend to you. Then Fiona Parkin, KC, will speak on professional negligence in construction, a journey of 35 years, which perhaps fits with Julian's topic. So Fiona is a barrister at Atkins Chambers, acting before both appellate courts and international arbitral tribunals. She specializes in large-scale commercial disputes, practice encompasses commercial disputes, energy, process plants, and utilities, as well as professional negligence and PFI disputes. Fiona is ranked as a leading silk in each of the fields in which she practices. I note that Chambers says that describes her as very eloquent and highly persuasive, so we will be able to judge that for yourselves in a moment. I also see, when I was looking at her profile, that she has been leading counsel in some of the very important cases relating to the topic she's going to speak on. Finally, Matt Malloy is going to speak on the title Adjudication since May 1998. So Matthew is a chartered quantity surveyor and chartered builder, and he's also been called to the bar. He's regularly appointed or agreed as an adjudicator and is on nearly all the panels of adjudicators except the ICE because he lacks that essential quality of being a civil engineer. Well, he speaks regularly on adjudication topics, and he is an external tutor with the College of Estate Management at the University of Reading. So, Richard Wilmot-Smith, I hope I haven't taken up too much time. Over to you.
Right, good morning, everybody. Just before we get to bonds and guarantees, I do want to mention briefly the topic Hamish Lowell talked about yesterday. I'm afraid I missed it, I had to go. The adoption of women into the legal profession has long been a problem. My first senior clerk told me that there were two types of people he did not want in chambers. One were parliamentary candidates and the other were women. I don't think that attitude lasted longer than it lasted far too long. And we are still looking at the consequences. It isn't just the appointment of adjudicators, which has its own particular problems, not least that there are many nominating bodies of adjudicators, but it also extends into arbitration and still extends into the bar. I think if you want to look at a set of chambers, it's well worth looking at the demographic. Those who are between 10 and 20 years call, what percentage are women? I look at outcomes, and the outcomes are still not good. We have a lot to do. I wish I had the answers. I've tried and tried various things. Some succeeded, some have not. But I think it's a combination of things is going to get us home where there's going to be true equality. But at the moment, things don't look great, particularly in international arbitration and adjudication. Now to the topic of the talk, performance bonds and guarantees. I had some experience in this, but it started around 30 years ago. But the talk may be a misnomer in that my conclusion is that the law has not developed much, at least in the area in which it covers. It must be said that in the last 20 years there's been a profusion of cases on the law of guarantee and indemnity, where old principles are considered and reconsidered. But there are three types of development. The first, the availability of bonds and guarantees on the market. Secondly, statute law. And thirdly, case law. I'm going to touch on the market briefly. These include the following instruments: on-demand bonds, conditional bonds, tender guarantee or bid bonds. That's to ensure the risk of a tenderer withdrawing the offer. Advance payment guarantee bonds. In the famous Mercer's case, it was procured to permit an advance payment for tax purposes. However, these instruments are highly popular because the advance payment eases a contractor's cash flow and thus enables site progress, where work intensity and expense is front-loaded. Fifthly, refund guarantees, being a guarantee of repayment of interim payments to contractors in the event that the employer under a construction contract or the buyer under a shipbuilding contract lawfully terminates the contract. These are more frequent in shipbuilding contracts because, of course, in a shipbuilding contract, the employer can tell the contractor to literally drop dead, walk away. Of course, in a construction contract, that doesn't happen because the realty, the work is annexed to the realty. Next, retention and maintenance guarantees. This again facilitates cash flow as opposed to a 5% or 2.5% retention being held by the employer. There is a bond which guarantees the rectification of defects. How this differs from, in substance, from a normal defect guarantee bond is going to be interesting. I'm going to escape any proper analysis by saying it all depends on the wording. And lastly, adjudication bonds, which is going to be my last or penultimate topic. This arises because the adjudication award has only temporary finality, and you can see there are problems which may arise there with a relationship of surety. Now, in an era where financial instruments form a large part of the economy of the country, there is room for the continuing expansion of their types, different types of bond being available on the market. Now, statute. The role of statute is limited but historic. A guarantee must be evidenced in writing. Otherwise, the Statute of Frauds of 1677, particularly Section 7, makes it unenforceable. Just got to quote the Statute of Frauds because in doing this talk, I told Renato yesterday that I hadn't prepared my slides and I had put by rote an illustrative case. And I realized this morning that the case may be right or wrongly decided, but the analysis was skew-if, and I will explain why in a second. But it brings you back to the statute. One of the first law lecturers I ever listened to was by Lord Scarman, who remarked that in all textbooks, The cases fill up pages and pages, and the statutes very few, but the statutes are fundamental. No action shall be brought whereby to discharge the defendant upon any special promise to answer for the death or miscarriage of another person, unless the agreement upon which such action shall be brought or some memorandum or note shall be in writing and signed by the person to be charged therewith, or some other person thereunto by him lawfully authorized. Lovely old pre-Bill of Rights language. It's a good example of Parliament looking to eradicate a mischief, and it stops one abuse, but may not prevent, the original draft said does not prevent, may not prevent a differently framed but identical obligation from arising. A differently framed obligation might be a contract of indemnity. However, the 1677 Act is an ancient statute which has survived attempts at its abolition. If you really want to hunger through Google, you can find the attempts to abolish it, including, oddly enough, in 1942. You'd have thought people would have better things to do than worry about that. And the one which you might be interested in is the Law Revision Committee, its 6th interim report, Statute of Frauds and Doctrine of Consideration, Command Paper 5549 of 1937. Now, the courts, so far as they were concerned, have upheld the Statute of Frauds, the latest one being Action Strength, which you've probably all heard of now, in 2003 appeal cases. However, there is a case called Brown, Forman Beveridge is Europe against Bacardi, which I was going to cite in my first draft through of this talk as being an illustration of how indemnity and guarantee differ. Because in that case, the judge at first instance in the commercial court held that the instrument was an indemnity and therefore was enforceable, even though it was not signed by the party to be charged. But in that case, what's interesting is the process which the learned judge went through. He had to decide whether the instrument was a guarantee, which required the statute of frauds, or indemnity, which didn't. The reference to statute, one word, the statute itself was not quoted, and the process which the judge went through was a process of contractual interpretation, citing all the old cases on statutory interpretation, looking at the overall obligation and saying, well, I think this is an indemnity rather than a guarantee. Fairly rote, you might think, but think about it, it's not. You have to look at the obligation against the statute. You do not construe the contract. Does the obligation fall within or without the statute? Is it an obligation to answer for the debt, default, or miscarriage of another? If it is, then it falls within the statute. If it doesn't, it doesn't. You shouldn't really be worrying about a rainy sky and all those mountains of cases which everybody feels compelled to cite whenever they have to interpret a contract. Development of law, has it developed when commercial court judges, with all respect to them, take that course because that's what they do? Law and guarantee is different. Now, as to case law, we must look at the on-demand and conditional bonds. The on-demand and conditional bonds have occupied us all since Trafalgar House and General Surety in 1994 and 1995. Somebody's waved at me, yes. That case was quite interesting for this reason, in that the first instance judge and the Court of Appeal ignored House of Lords authority to hold that a standard conditional bond was in fact an on-demand bond. The first instance judge didn't quite go that far. He merely said, well, there were losses. He didn't bother about set-off, and therefore there should be payment. But the House of Lords, the Court of Appeal, to the consternation of counsel arguing in front of him, and it was a very strong Court of Appeal. It had Lord Bingham as Master of the Rolls and and it had Lord Justice Savile, as he then was, who was then pushing the response, who said to counsel, well, is this a see to it bond? Yes, says counsel. But then he goes on, and the court went on to hold that it was effectively an on-demand instrument. Prior to that case, there hadn't been much on conditional or on-demand bonds. So that case, about 8 or 9 years after the founding of the centre, about after Trafalgar House and General Surety to date, I've been able to find electronically around 60 cases on the distinction. Quite interesting that there should be that profusion. But the House of Lords put it right and held that the particular instrument under consideration was a conditional bond and was not an on-demand bond. And the profusion of cases which has occupied the years since has been as to whether a particular instrument was on-demand or conditional. I cite in the paper, and Renato, I will give the revised paper with the proper reference to the Bacardi case. It is Lord Diplock in United City Merchants, where he sets out the characteristics of the on-demand instrument, which effectively were banking instruments. The on-demand bond really, in terms of examination in English law, began in 1978 with Edward Owen Engineering Limited against Barclays Bank, with the then profusion of on-demand bonds given particularly in Middle East countries, where the demand on the instrument did not require a proof of performance between the person who is making the demand and the bank. The difference between an on-demand and a guarantee bond is one where liability is established through the presentation of documents, being the on-demand bond, and the other one where the guarantee is triggered by default. One can summarize the development of the law since Trafalgar House, if you can call it development. That is, there have been many cases before the courts where the argument has been whether the instrument was an on-demand bond or a conditional bond. Now, that might be thought odd, that there should be many such cases. But what seems to happen is that there's a profusion at the front end of the industry of what I call certain degrees of word salad, whereby little bits which tend to show it's an on-demand instrument, upon a first written demand, for example, being an obvious one, immediately being another, go hand in hand with default or established losses or other such words, leading the first instance judges there to try and construe which one it is. Now, most recently, the Court of Appeals tried to make sense of it all in a case called Shanghai Shipyard against Rainwood, and that's in 2021. And the judgment of Lord Justice Popperwell is well worth reading. I'm not going to go through it, but what I do suggest, if you want to know the difference between on-demand and the conditional bonds and see how they are construed and track your way through the process, you can't do any better than to read Lord Justice Popperwell's judgment. Paragraph 32, I will quote from. What this illustrates is that in the present context, there ought to be no room for a priori preconceptions or assumptions about the nature of the instrument to be derived from the identity of the guarantor. Because in the intervening years between Trafalgar House and 2021, one of the factors which was brought into argument, and indeed in one or two first instance cases was used, was the identity of the bondsman. If it's a bank, then that triggered the assumption that the bank was because it was a bank, then the party, the instrument was on demand. If it was a professional surety or a parent company, then that suggested that it was conditional. And what Lord Justice Popperwell says, I think absolutely correctly, what matters is the wording which the parties have chosen to express their bargain, interpreted in accordance with the well-established rules of construction. One little gripe, if I may have, in relation, and you will have if you come to study this, either as academics or because you've got an on-demand conditional bond problem, is the profusion of authority. It's remarkable how in all the cases the authorities, the numbers of authorities, just stack one upon the other upon the other. In that case, Lord Justice Popperwell said at paragraph 35 in a little passage that I can't resist, there are only two cases which engage the legitimate line of argument in the present appeal. Lots others, of course, cited. In my view, and he gives their names, although I will have to refer to some others cited by the parties to explain their irrelevance. Now, he then, it's not particularly interesting as a matter of legal theory to decide whether the Court of Appeal is right or wrong in whether it was an on-demand instrument or not. In that case, he held it was an on-demand instrument. The process of construction is interesting because he lists out all the topics, all the pointers, some of them that I pointed out, the terms immediately, for example, first written demand, established loss, and weighs them up and arrives at a conclusion. That's a process of construction which is jurisprudentially not particularly interesting in an individual case, but is a good illustration of the process of construing those particular types of instrument. Now, some things remain as regard on-demand bonds. Subject to the fraud exception, a properly constituted demand triggers payment. There's been a recent trend of cases which indicate that perhaps the types of demand don't have to be absolutely 100% specifically in accordance with the instrument. It's going to be interesting to see how that tension works out because, of course, in banking instruments, it's the precision of the demand which is crucial. And here you seem to have a mixture in the cases of moving away, perhaps, from technicality, which a banking lawyer would not perhaps permit. All of them have the fraud exception. And the fraud exception in the cases is particularly interesting to trace because in on-demand bonds, it's the fraud which is the only exception to the requirement of the bank to pay upon a properly constituted demand. However, 2014 is a banner year for the fraud exception because prior to that, there were a number of cases, TTI Telecom being one in 2003, Simon Carves and Enos in 2011, three actually, and Doosan in 2013, which moved towards cyanamide principles in cases where an injunction was sought against the call of a bond. Two types of injunctions sought, one preventing the call, two preventing the payment. All sorts of cases historically dance on the head of a pin as to whether there's a distinction between one or the other. I think in banking terms there shouldn't be. But the fraud exception was, I think, definitively dealt with by the Privy Council in a case called Alternative Power Solutions against the Central Electricity Board, where, because time is running, I'm going to skip, but basically the fraud exception is truly the fraud exception. It isn't unconscionability. There's a line of cases in Singapore which suggest unconscionability or other such matters can obtrude into the process of whether an on-demand instrument is to be called or not. And I have 2 minutes, so I'm going to rush. Now, what I'm going to rush to is what I call adjudication bonds, because there is a recent case in the TCC by Mr. Justice Fraser called Uanda against Multiplex, in which it was held, I think, per incuriam, that an adjudication decision demand made under a standard conditional bond, not an on-demand bond, which made no provision for an adjudicator's decision, required payment by the guarantor on the adjudicator's decision. Now, that case is wrongly decided. And the reason why it is that it wasn't properly argued. And the reason why it wasn't properly argued was that the surety decided, it's plain from the report, not to take the point that its obligation depended upon performance and not certificate or award. And you only have to go to many of the cases which dealt with that. And I list them in the paper, but I'm just going to quote one. It's a judgment of Mr. Justice Foxton in SK Shipping. And there's another one, Mr. Justice Ramsey in Beck Interiors. I recommend Beck Interiors because it saves you scurrying around to look at all the other cases which go historically back to 1875, where it's made clear that it depends on performance. Easy to see how the trap gets into, because there is a line of authority which says that an obligation of a contractor includes an obligation to obey an arbitrator's award. If that's right, and an arbitrator awards a certain sum of money, why shouldn't the guarantor be required to pay it without proof of the losses? The cases explain why that's wrong and why that shouldn't be the case. But you can also see why a professional bondsman would decide that it was not really interested in that, going into that it would rather pay if it's held to be by an adjudicator. The liability is held that way. And that's why I think the decision of the learned judge in that case was wrong. I dare say it won't go to appeal because, of course, if the bondsman decides it's not going to argue the point, then it's not going to go to appeal on that point. But there has been, as I say, quite a lot of cases, but most of them meander around the same particular points. But I thought I'd mention the adjudication one at the end because that's the latest one. Adjudication's 1996. Adjudication bonds are relatively new, and you do have that decision, which makes no sense. Why on earth should a bondsman pay upon an adjudicator's award, but not an arbitrator's award? Doesn't make sense. Finally, it illustrates, read the reports carefully before you tuck away a conclusion, just as I should have with the Bacardi case. Thank you.
Good morning, everyone, and thanks, Richard, for that great presentation. I'm going to begin with an embarrassing confession. For those who were here yesterday, you might recall Professor Nazzini on a couple of occasions mentioning the origins of this conference. And it started life, shall we say, about a year ago when I sat down with the professor and we had a bottle of Burgundy and talked about the idea of a 35-year conference. And so we came up with a program, a schedule, topics, speakers, etc. And I allocated something to myself, which is this particular topic. And my confession is this, that at the time when we were drinking Burgundy and thinking about topics, I obviously had something in my mind that I wanted to talk about. But 2 weeks ago when I started to prepare my slides, the idea had completely left my mind. So I have to start again. And what I am going to talk about relates in part to fitness for purpose, but a lot of it is about windmills. And when I was starting again and thinking what I was going to talk about today, I was thinking, what is it about fitness for purpose obligations that people get worried about, contractors in particular? They seem like onerous obligations that contractors face. And I think also the reality in the insurance markets is you can't insure yourself in respect of fitness for purpose obligations a lot of the time. So it creates issues potentially for contractors in particular. But what I want to get into is really, what are we talking about here? Are we talking about a major obligation, a giant that rears up before a contractor to crush it every time they sign a contract with a fitness for purpose obligation? Or are these obligations part of the fabric of construction law? They're always there anyway, and contractors have these obligations, in which case they're more like windmills. So what is this particular issue? Well, and how does it arise? Well, it arises when we have construction contracts, and the contract will say the contractor is to provide something X, X could be a windmill, for example, and that X is defined or set out in the contract in some way. And so the contractor duly goes ahead and supplies X, builds the windmill, but X turns out to be defective. There's something wrong with it, meaning that it's not fit for its intended purpose. But in a typical example that we'll come to in a moment, the contractor's done nothing wrong. It's provided what the contract says it has to provide. It's exercised reasonable skill and care. But yet the X, the windmill, for example, might be unsuitable. So is the contractor liable for the unsuitability, the lack of fitness for purpose of the particular item? And the issue becomes a hard issue for contractors in particular, because the liability is strict. It arises irrespective of any kind of fault or negligence on the part of the contractor. Oops, I went too far. So where to begin? Well, I thought we could begin with a factory, which is in Staffordshire. This is the Duckham's factory, and it should be interesting for people in the motor racing world and in the culinary world. So you see here from the slide, to cope with the demand of motorists' desire to give their car engine the utmost care, a new manufacturing plant was opened in Aldridge, Staffordshire, in 1968. That's good. The previous home of Duckham's in Hammersmith was later turned into Thames Wharf Studios and famous Michelin-star River Cafe. So we can thank Duckham's for giving us this wonderful restaurant here in London, but that's not what this case is about. The case is about the factory you see on the slide there. And the background to this, there was meant to be a picture of Lord Denning there, but he's disappeared for some reason. So Lord Denning gave the background to this case, which you can see here. And he says this case arises out of a new kind of building contract called a package deal. So back in the 70s, even the concept of design and build, or EPC, was not even known. It was a package deal. The building owners were Alexander Duckham & Co. They wanted a new factory, warehouse, and offices to be constructed at Aldridge. The warehouse was needed as a store in which barrels of oil could be kept. This is what they make, oil. Until they were needed and dispatched, in which case they'd be moved safely from one point to another. The package deal meant that the building owners did not employ their own architects or engineers. They employed one firm of contractors to do everything for them, called Greaves. It was the task of the contractors not only to provide the labour and materials in the usual way, but also to employ the architects and engineers as subcontractors. The contractors were to do everything as a package deal for Duckham's. So that's the background there. We think of it as design and build. That's what Duckham's got. So what happened? Well, we've got this warehouse that's going to be built in Aldridge. The oil is going to be moved there in barrels, and then the barrels are going to be moved around by forklifts, unsurprisingly. And the contractor here engaged reputable designers. There's nothing wrong with them. And they appointed seemingly competent people. The design was done, the factory was built. After construction, some cracks started to appear in the slabs as the forklifts went around carrying the barrels of oil, and it became a real problem, to such an extent that the warehouse became unusable. They couldn't use it anymore. So that's a pretty major problem. Now here, the purpose of the warehouse was known all along. This is Duckham's, they make oil. It's for storing their oil and moving it around. So there's nothing unusual particularly about that. This was known to the contractor. But the question we're looking at is, well, what were the contractor's obligations to the employer in relation to this package deal? And there's Lord Denning there listening to his favourite music, Metallica or AC/DC or something like that, I'm guessing. But he summed it up here. And this summarises the position of English law in relation to implied fitness for purpose obligations. He said, now, as between the building owners and the contractors, it is plain that the owners made known to the contractors the purpose for which the building was required, so as to show they relied on the contractor's skill and judgment. It was, therefore, the duty of the contractors to see that the finished work was reasonably fit for the purpose for which they knew it was required. It was not merely an obligation to use reasonable care. The contractors were obliged to ensure that the finished work was reasonably fit for the purpose. So there you have it. That sums up English law then and now in relation to fitness for purpose obligations. They will be implied into a construction or engineering contract. And there are really I think, two key aspects to this when it comes to implied fitness for purpose of obligation. The first one must be the communication by the employer to the contractor of the purpose of whatever it is, the structure. That will usually be, I think, apparent to any contractor. You know, the employer says, I want a warehouse built. Oh, we have barrels of oil we want to ship from here. Okay, that is the purpose of the warehouse. It will be known to the contractor, usually. That's the easy bit. But then we've got a critical bit, I think, and we'll see a bit more about that in a moment, which is reliance by the employer on the contractor to use its skill, its judgment, to produce this product which is reasonably fit for its known purpose. And we're going to look at that in the context of a case about a windmill. And this case, Bowers, from 1910, is about a windmill in a lovely place in Derbyshire, which will be known to Professor Uff, I'm sure, Wormhill. And so in this particular case, the windmill was needed to pump water for a village. And a contract was signed between the council and the contractor, Bowers. And the contract included the usual sorts of things, drawings and specifications, and it included this particular provision. So it said, the contractors will be required to obtain the windmill tower and pump from Messrs. Rickman & Co., Windmill Engineers, 13 Walbrook, London, EC, which the sum of £127 has been included in the quantities. Now, I don't know if this Rickman was related in any way to the sneering Alan Rickman you see there, but what I can say is that 13 Walbrook is actually the location of the London Mithraeum. So the engineers obviously weren't particularly good at their job, as we'll see at a moment. They left, and later on, Bloomberg and the museum emerged, thankfully. So this is what the contract said. You have to get a windmill from Rickman's, and that's what the contractor duly did. And so what happened? Well, we have a bit of a narrative here from the judge, Mr. Justice Lawrence, who I've had a little note here about his lordship, which coming from, this note is written by Lord Justice McKinnon, one of the great arbitration lawyers and judges, and his assessment of the judge was, Mr. Justice Lawrence was a stupid man, a very ill-equipped lawyer, and a bad judge. So that's about as scathing as you can get in relation to Mr. Justice Lawrence. In fact, as an aside, he was so bad, he's described as the begetter of the commercial court. He had a commercial case, which he messed up so badly that people here said, we need to get a specialist court to deal with this type of case, and that's how the commercial court was created. He didn't mess up this case, I think. I think he was okay here, but this is what he said about the particular windmill. He said, the windmill was unable to perform its duty. In the end, it was abandoned altogether. It was absolutely useless, and a new mill of a different construction, procured from a different place, was obtained by the council, the employer. The work went on, but the mill broke down on January 17, 1910, and that caused a considerable amount of delay. So the windmill specified by the council was procured, it broke down, they had to get a new one. The council told the contractor, well, you need to get a new windmill, and by the way, you are responsible for the delay caused because the original windmill didn't work properly. So the question here was whether the contractor was liable for the very specified windmill not working. In other words, was there an implied fitness for purpose obligation? And his lordship said this. He said the mill was chosen by the employer, the council, and it was the mill that the contractors were bound by their contract to erect. It was not part of their contract to guarantee in any way that the mill would be efficient. So that seems like a fairly clear assessment of the nature of the contractor's duty here. The judge said there's no fitness of purpose obligation that will be implied because the contractor was supplying what it was told to supply. There was no reliance by the employer on the contractor's skill in this regard. So the fact that the windmill was not functioning was not something the contractor took responsibility for. So that was a case about a windmill 100 years ago. Let's now move forward in time a century or so, and we'll look at express fitness for purpose obligations. And I want to look at a case which is probably better known than the last one. This is the Hoygaard case, and it relates to the Robin Rigg wind farm in Scotland, which you see there on the slide. The contractual arrangements here were unsurprisingly a bit more sophisticated and a bit more onerous too for the contractor. So we had an EPC contract whereby the contractor agreed to build a wind farm for a certain amount of money. There were provisions about design life, so it said there had to be a 20-year design life for the wind farm. For the foundations, there was a bit saying that foundations should have a 20-year design life, and in the bit that seems to have become chopped out somehow, it also says that the works had to be fit for purpose. So there was an express fitness for purpose obligation in this particular contract. Contrast the previous windmill case where we didn't have that. And something's gone slightly wrong here, but we can continue. The contract, as many will know, contained a particular provision in relation to the design that the contractor was to prepare. It said, thou shalt follow this particular international standard in designing the foundations, D&V standard. And that's what the contractor did. They followed the standard, but there was a slight problem in that the standard had an error in it, which basically meant that if you followed it in this particular case, the foundations were under strength by a factor of 10. So rather than the wind farm, the foundations lasting 20 years, it was going to fail after a short period of time. So it's quite clear the foundations for each of these wind turbines weren't fit for purpose, and the question was the contractor liable for this? And there was a bit of argument in the courts, including going up to the Supreme Court about it, because the contract was a large contract which had possibly conflicting provisions. But we need to understand here, of course, as with the Bowers case, the contractor had done nothing wrong. It had exercised reasonable skill and care in designing the foundations for these particular turbines. So the question for the court, and it went to the Supreme Court, was whether there was, in effect, a fitness for purpose obligation that overrode everything here and made the contractor liable despite the absence of fault. And in the course of the judgment given by Lord Newburger for the court, he said, while each case must turn on its facts, the courts are generally inclined to give full effect to the requirement that the item as produced complies with the prescribed criteria, on the basis that even if the customer or employer has specified or approved the design, it is the contractor who can be expected to take the risk if he agreed to work to a design which would render the item incapable of meeting the criteria to which it has agreed. So there's a fairly clear statement there that the contractor will generally take the risk of the supplied item not performing as it should. So what can we conclude from this little journey through the world of windmills? I posit three conclusions. The first, which I think is important for everyone to remember, is that under English law, fitness for purpose is generally implied into construction and engineering contracts. It may not be stated in a contract, but the law implies it, as Lord Denning indicated in the Greaves case. The second point, which again comes out from the Bowers case, is that reliance by the employer on the contractor's skill is a key thing to whether or not this obligation will be implied or not as a matter of English law. If the employer isn't relying on the contractor to exercise reasonable skill and care, as is the case where the employer says, this is what thou shalt supply, then we don't have an implied fitness for purpose obligation. So that deals with implied obligations, but express fitness for purpose obligations are, as I suggest, a different kettle of fish. And there's no need where you have an express fitness for purpose obligation for there to be any kind of reliance by the employer on the contractor's skill and care. The obligation exists because the contract says this is your obligation. So it's that obligation which contractors are generally wary of. And I'm conscious of the time, so it's time to fly. Thank you.
Good morning, everybody. As you can see, the topic of my talk this morning is professional negligence in construction a journey of 35 years. Not only is 35 years the anniversary for the King's College Centre of Construction Law, it's also my own personal anniversary of studying law. I started in 1986. 1987 marked the conclusion of my first year in which I read Law of Tort. If I had been standing in front of you in 1987, this would have been a relatively short talk. In particular, I would have said to you that professional negligence in terms of cases for construction professionals are cases about physical damage as a result of the House of Lords decision of Anns and Merton in 1982. I would have also told you that if you had to understand when a cause of action in tort accrued for the purposes of starting a professional negligence claim in tort, the answer was provided to you by Pirelli, and the answer that Pirelli gave you was that the cause of action accrued when damage occurred, damage for the purposes of a construction professional negligence claim being the occurrence of any form of physical damage to the building. So that was pretty straightforward. However, since then, what we've done, as we'll come on to discover, is essentially create for ourselves a degree of complication and muddle such that standing here in 2022, it is no longer possible to identify with any degree of precision when a cause of action might accrue in a professional negligence case. Why might you say, does that matter? It matters because professional negligence cases frequently concern the concept of latent damage. And in relation to construction professionals, what that means is one prepares a design which is built, but the consequences of the defect in the design do not materialize for some considerable period of time thereafter. The simple approach started to go awry in 1991 following the decision in Murphy and Brentwood, a case with which anyone who's done any form of construction law, I hope, will be familiar. Murphy decided that although Anns had characterized loss for the purposes of construction cases as physical damage to the building, that was no longer the correct characterization of the loss. And in fact, what was happening was that the damage to the building ought to be characterized as economic loss because it was damage to the thing itself, which was therefore of a lesser economic value than it would otherwise have been. They explained Murphy and Brentwood, they explained Pirelli as a case being decided on a Headley-Byrne basis, namely a case in which I'm so sorry, I'm being told to speak to the microphone now for the online attendees, so I'm going to move that forward. They described Murphy and Brentwood as a case in which, in Murphy they described Pirelli as a case in which the Headley-Byrne special relationship explained why there was a duty in that case to protect against economic loss, namely the damage to the building. However, since Murphy, and in a case which I think is probably quite well known to Mr. Wilmot Smith sitting over there, if he can reach back into his memory for the past 12 years, the courts have also concerned themselves to consider other kinds of economic damage arising out of professional negligence. And in particular there, I've identified two cases, Howe and Southern and Co-op and Burse, both of which were claims arising out of a contractual chain in which subcontractors were held to owe main contractors duties in relation to claims that might be brought against main contractors by employers. And in particular, Co-op and Burse, following on from the decision on liability in Howe and Southern, Mr. Justice Stuart Smith said, in a case where the development is being constructed for someone other than the main contractor, the primary risk that should be in the contemplation of the parties will be that the main contractor will build and hand over a defective building to the employer and thereby incur liability. His liability will usually be measured by the cost to the main contractor of undertaking repairs or the sums necessary to compensate the main contractor for the defects. So importantly, two forms of economic damage or loss have been identified as flowing from breach of a duty to exercise reasonable skill and care. So far, so good. However, when one comes to look at limitation and the accrual of causes of action, the question is, when is damage first suffered for the purposes of giving rise to a claim in tort? Now, here matters start to diverge somewhat, depending upon whether or not one is suing in relation to damage to a building, where one is the building owner, or whether one is suing in relation to damage to other economic interests, as was the case in the Howe and Co-op and Burst case. And the result of both of those developments in the law, in those two strands there, is that we get a series of different dates which arise for the identification of damage for the starting of a cause of action. As I set out on the left-hand side of the page, Pirelli, which, as you'll see from the extract from Abbott and Will Gannon and Smith, 2005 Court of Appeal decision, is still good law in in England and Wales, says that you have to establish that there is physical manifestation of damage arising out of a latent defect, and until such a point in time, you have no cause of action. And as we know, the physical manifestation of damage arising from a latent defect might well not occur until some many years after the defect in the design was incorporated into the building. In Pirelli, it was about 3 years, but in other cases, it could be significantly longer. However, courts in relation to accrual of causes of action for the other form of economic interest have taken a rather different tack. And what they've said is that loss occurs from the point in time, the earliest point in time that there is damage to one's economic interest. Now, again, rather like an elephant, easy to state, but perhaps not quite so easy to unpick. When we look at when relevant loss was first suffered to economic interests, once again, there is some divergence in judicial authority about when that might be. Although we might all sit here and think it's pretty straightforward to identify when we suffer economic loss, namely it's when we notice that things are worth less than might otherwise have been expected, the courts in some cases have taken a rather different view. Starting with what might be called the conventional approach in Linklaters and McAlpine and Howe, this was a judgment of Mr. Justice Aikenhead, again a case in which Richard was involved, in which Mr. Justice Aikenhead held that where there is a claim for professional negligence and the damage is damage to economic interest, loss occurs, as we can see there, at the point in time that the claim was made up the line. So in that case, that was a case brought by Linklaters who'd suffered damage to its air conditioning system. It sued the main contractor, and the main contractor joined Howe as its M&E subcontractor, and in turn, Howe sued its specialist M&E design installers for the costs that it said it would incur in settling or being made liable to Linklaters up the line. When then did Howe's loss crystallise? Mr. Justice Aikenhead identified the point in time that Linklaters made the claim up the line, because that was the first point at which it could be said that a claim was intimated. However, a slightly different approach was taken by Mr. Justice Stuart Smith in a case of Co-op and Burse in 2014. Again, there, Co-op, being the owner of the building, sues its main contractor, Burse, for damages to a floor, and Burse seeks to recover sums due from its subcontractor. Mr. Justice Stuart Smith, having considered Mr. Justice Aikenhead in Linklaters, declines to follow the Linklaters approach and says that the point in time at which Burse's cause of action against its subcontractor accrued was the point in time that Burse suffered what are known as damage to its package of rights. And the package of rights there was the rights that Burse had under its contract with the employer. And Mr. Justice Stuart Smith said that the point in time that Burse suffered damage to those package of rights was the first point in time that it relied upon the design prepared by its subcontractor and thereby provided the employer with a defective building, because it was at that stage that Burse was open to having claims made against it. So, unlike Linklaters, Co-op and Burse brings forward the date upon which a cause of action in tort accrues, and it brings it forward to the first point in time that there could conceivably be damage to one's package of rights. Now, that seemingly strange position where one has, depending on the cause, whether or not one has an interest in a building or one is simply seeking to sue to pass down losses incurred under a contractual chain, has led at this point to 3 potential dates for the accrual of a cause of action for professional negligence. The first being Pirelli, namely the date upon which the physical damage occurred. The second being Mr. Justice Aikenhead's view of the world, being the date upon which a claim is made in relation to the defective work itself. And the third being Mr. Justice Stuart Smith's view of the world, namely the cause of action accrues upon a building contractor passing up a defective building to his employer and thereby occurring for himself potential liabilities down the line. I think that's an extremely unsatisfactory state of affairs for the law to find itself in. In particular, it's extremely unsatisfactory if one has to advise clients about whether or not they've got a claim, and if so, whether or not that claim is or is not statute barred. What is the solution to this? In some senses, the solution has potentially already been postulated by the Privy Council in a decision called Invercargill and Hamlin way back in 1996. That's a decision of the Privy Council concerning the law as it was in New Zealand. Now, New Zealand doesn't follow Pirelli, takes a different approach to the accrual of a cause of action. And what the Privy Council found in Invercargill is that it's important to look at what's really going on in terms of a professional negligence case. And I've set out there the quotation from the judgment, which I think has an awful lot of common sense attached to it. Once it is appreciated that the loss in respect of which the plaintiff in the present case is suing is loss to his pocket and not for physical damage, that's the change that was implemented by Murphy doing away with ANS, then most, if not all, of the difficulties surrounding the limitation question fall away. The plaintiff's loss occurs when the market value of the house is depreciated by reason of the defective foundations and not before. If he resells the house at full value before the defect is discoverable, he suffered no loss. Thus, in the common case, the occurrence of the loss and the discovery of the loss will coincide. So, Invercargill is authority for the proposition that in New Zealand, at least, damage is suffered when one actually experiences the economic loss itself. There's some support for that being the right approach to the accrual of a cause of action in tort if Pirelli were to be overruled. In the Abbott and Will-Gannon decision, which we touched upon a moment or two ago in the Court of Appeal, where the Court of Appeal held that if they were not bound by Pirelli and that they were starting to look at the matter afresh, he said, the judgment in the Court of Appeal, I do not accept the submission that loss occurred when the works were completed to the engineer's design. Now, pausing there, that submission, namely that loss occurs when the works were completed to the engineer's design, is precisely the submission which Mr. Justice Stuart Smith in Co-op and Burse accepted in relation to that second category of economic loss, which we discussed earlier on in this talk. So not accepted by the Court of Appeal in Abbott and Will-Gannon. Instead, say the Court of Appeal, if we're not going down the lines of Pirelli, the defective design has not caused any loss at that time, namely when it is constructed. It would only do so when it manifested itself in some way which would affect the value of the building. In other words, I accept Lord Lloyd's analysis in Invercargill. So the Court of Appeal there giving the hint that if Pirelli is to be departed from in future, the correct approach for construction lawyers advising on when claims in professional negligence in tort accrue is the point in time that loss is in fact suffered, namely the point in time at which there is some effect on the value of the building. And as you'll appreciate, that effectively brings the date for the accrual of the cause of action way forward because it elides the starting point with the date of the discoverability of the damage and not the date upon which the damage itself accrued. Finally, and bang up to date, in another decision of Mr. Justice Fraser, which I also think is wrong because I lost in it, BDW Trading and URS going to the Court of Appeal next year, Mr. Justice Fraser found something completely different. BDW Trading and URS is an interesting case. It's interesting because BDW Trading had a proprietary interest in the buildings at the time the buildings were built, but subsequently sold it on for full value to third parties. It was not the subject of any claims by third parties, but decided for reputational reasons to carry out remedial works rectifying the problems with the design which it said it had uncovered in the tower blocks which URS had designed. So there are very difficult questions in BDW about the nature of the loss and the date upon which the cause of action accrued and whether in fact any loss was suffered at all. And this is what Mr. Justice Fraser said. He says, the measurable loss in the case of a negligently designed structure that has been constructed is the cost of making it structurally safe. That occurs when the structure is constructed in accordance with the negligent design, thereby setting himself at odds with the Court of Appeal in Abbott and Will-Gannon, and very much at odds with the Court of Appeal, with the House of Lords in Pirelli, who rejected that approach as the proper approach for the accrual of a cause of action for professional negligence, and seemingly accepting the approach proffered by Mr. Justice Stuart Smith in Co-op and Burse. And we will have to watch the space next year to see what the Court of Appeal make of all of that. Thank you.
Okay, good morning. An absolute pleasure to be here. I think if I'd been here 25 years ago, I might have felt I was going a bit into the lion's den if I professed to be a fan of adjudication. So forgive me if I'm a bit nervous, and indulge me if I miss out something along the way in the time that I've got available to talk about adjudication since May 1998. Wow. There you go. Thank you. Well. Okay, well, what I'm going to cover, I'm not sure what your skills are like at looking at the rearview mirror. You're probably going to see it, but I'm going to cover, here we go. I'm going to cover the pre-May 98 landscape, what was the scene then, and then I'm going to jump to where we are now. And I confess to doing that because there is so much to cover, and I would expect that the audience will have some knowledge of some of the jurisprudence along the way. And I'm also going to comment and perhaps talk about where we might be going next. The pre-1998 landscape, I'm going to touch on the debate that was going on at the time, and I think you need to sort of go back to 96 and 97, and I recommend perhaps reading the first chapter of Coulson on adjudication, which really sets the scene of where we were at that particular time. Before I do that, I'm going to just touch on the perceived training requirements, because there was a concern of, well, who are these adjudicators going to be, and what qualities should they have? And I think it's fair to say at the time, the pool of adjudicators that the market was looking at was the arbitrators who were already in vogue, and they sent them away for a day or a weekend to learn about this newfangled procedure and encourage them to sort of make it up as they go along. So the debate, and I'd imagine that we were here, and I'd imagine someone on the third row to my right, to your left if you're looking at the screen, may have been in charge of a debate. And again, I've got the reference up here on the slide. There was a set of papers, and you probably don't really need to read into it other than just look at the cover, because it said A Plea for Sanity, edited by John Uff, QC at the time. So it was a collection of papers in opposition to the 95-97 proposals. There were serious concerns about the ability of adjudicators to deal with the complex issues that construction law threw up. And we've heard some of those issues that I've seen, perhaps surprisingly, during my path as an adjudicator. So there were concerns. There's a fantastic article by Ian Norman Duncan Wallace, Adjudication, Swarms of Wannabes. And in his infamous style, he was quite scathing as to these wannabes who were going to go out there and deliver justice in the way they saw fit. His particular concern was that the adjudicators were coming from the industry and they had a contractor bias. Whether that was true or not, that's for others to say. But that was a particular concern of his, and he wrote quite extensively on this subject, and very persuasively and very robustly. So now we're going to go to where we are now. And the thing that has struck me on the journey along adjudication is that we are very much an embedded part of the litigation landscape now. Why is that? One of the first, I think, signs that adjudication was going to tick off was the Mackup and Morrison judgment. Mr. Justice Dyson at the time, who was the head of, I'm not sure if he was official referees then, and I'll come back to that in a minute, or the Technology and Construction Court, but he basically, I would suggest, invented a way of enforcing an adjudicator's decision. All of a sudden, this baby had grown its teeth, and people realised that if an adjudicator ordered someone to pay money, you better do it. If you don't, you're going to have a court judgment, say for certain reasons that you're going to have to pay over. I was thinking when I was listening to Richard, Julian, and Fiona as to the very complex subjects that they were covering. I recently saw a bond that would pay out on the consequence of an adjudicator's decision that was contested or a judgment. So we're now starting to see the effect of adjudication in more, perhaps, elevated circles than we anticipated at the time. Professional negligence, they don't come along so frequently, but in a contractual setting, and I think colloquially professional negligence, I mean in the contractual sense, is a visitor to adjudication. And we have to deal with, or we get to deal with, quite complex professional negligence cases in conjunction with litigation, either concurrently with litigation or as part of pre-action protocols. Fitness per purpose, again, comes across my desk. And it's fantastic in terms of every day is a school day, but it is quite challenging in the time constraints that are there to actually deal with these matters. And that was one of the earliest concerns. The analogy with the official referee, I think, is quite pertinent. There was, if you look back at the time that adjudication was holding its feet, a concern about the quality of the official referee's court. Next year will be the 150th year or the anniversary of the official referees, now's the Technology and Construction Court, and it will also coincide with the 25th anniversary of the enactment of adjudication. There's no doubt in my mind that the success of adjudication owes itself in no small part to the support it has had from the judiciary and in particular the Technology and Construction Court. When I looked at some of the concerns with the official referees or even the purpose of the referee, their role was to deal with these technical construction disputes that were perhaps seen to be beneath the commercial court judge. But there's been a change in the Technology and Construction Court, not just in name, but although the official referee's business goes through to the Technology and Construction Court, the official referee now, who was perhaps referred to, or no, actually referred to as a cadet judge, was given what they call red judge status. So they were put on an equal footing and brought within the business and property court setup and on an equal footing with the commercial court. Now, in my view, one of the reasons for the success and the support of adjudication as a process is the types of cases they are dealing with are the cases that the official referees used to deal with, and they're having to deal with them in a very cost-effective and efficient way because they've got time constraints upon them. So, looking at where we are now, I'm going to refer to a couple of quotations from Lord Justice Coulson as he is now. And they struck me at the time, and they still strike me as being very, or good examples of the esteem or the support that the TCC give to adjudication. So S&T and Grove at first instance, and I think this was Lord Justice Coulson's parting gift from the TCC when he was at that level, it agreed with counsel that if the court had the power to do something, then so did an adjudicator. Now, that was news to me, and I felt quite proud walking to the station the next morning, but I think it gave you a flavour of what the judges were saying about these cadet judges, perhaps. Bresco, in the Court of Appeal, analogy with an arbitration, and they said, well, on analysis, I can see no reason why, purely as a matter of jurisdiction as opposed to utility, a reference to adjudication should be treated any differently to a reference to arbitration. So again, more support. With increased status comes increased responsibility and scrutiny. And I'm not going to go through the details of the case, but if you do have the time to click on the 2019 series of cases that I've cited there, you will see quite painstaking investigation into what the adjudicator did and what didn't do. Because I think generally the role of the TCC is, well, providing you've got jurisdiction, providing you've behaved yourself, providing there's no fraud, providing there's no insolvent beneficiary, we're going to enforce, but we need to make sure that you're behaving. And I think that's a good thing, because it keeps the house in order, and it calls out bad behaviour and conduct, and also keeps us on our toes. Where are we going? The process has become increasingly complex and important, and because of that, I think there is an increased need for a level of training and experience, and also to enable an increased need for people to get some hands-on experience, and I've mentioned pupillage and mentoring there, because I think whilst the master's course here and other followers include adjudication as part of the syllabus, I think there's a step to be filled in terms of allowing those who've been given the knowledge to actually go on to practice. And that might come into or tie into some of the things we've heard about in terms of diversity and preparing the next generation of adjudicators. I'm just going to touch on a couple of areas in terms of where we're going. One of the consequences of adjudication becoming so successful, dealing with these complex cases, is the one end of the industry was saying, well, this is too expensive for us to deal with, and we've lost the purpose. Yes, you've lowered the entry level into dispute resolution, but we can't afford it now. I think there have been steps put in place, successful, to cap the adjudicator's fee, and I think we'll see an increased demand for that, especially over the next 2 or 3 years, which I suspect for the dispute resolution fraternity is going to be a busy time. We're also seeing people looking at what the UK have done in particular and export it, not just within the UK in terms of what the construction industry is doing, but actually what the country's doing in terms of exporting it beyond the jurisdiction of the UK. So there have been calls from judges to widen the process. The process industry resisted successfully having adjudication dumped upon them. We've seen, I didn't realise, but there's a pubs code adjudicator out there. Sounds like a good gig. But it's a statutory form of, it's effectively arbitration, but it's a fast-track process for tied tenants. We're seeing the internationalisation of adjudication, not just to common law and ex-Commonwealth countries. I know that some civil code countries are looking at introducing adjudication because it lifts the burden or takes the burden off the public purse to deal with domestic construction disputes. We're also seeing the skill set of adjudicators being used elsewhere. So dispute adjudication avoidance boards are starting to be introduced or talked about, at least in the UK. Evaluative mediation. So I've noticed that the adjudicators are being drawn upon to use their knowledge and experiences to help parties to resolve and assess their risks on the basis, well, if this does end up in adjudication, where is it going to end up? Closing remarks. We've now got a mature, complex and a highly legal process. This comes at a cost, which can be a plus and a negative, depending what side of the checkbook you are at, and then also an increased need for quality and also accountability. I apologise if I've run over. All I want to say is thank you.